5 seconds to go. Start. As far as the recovery of alleged looted articles are concerned, that was recovered after information by informant PW5 from all the five appellants, but that was disbelieved and no appeal has been preferred. So the argument in respect of recovery, where it is under section 27 of the Indian Evidence Act or covered under section 8 of the Evidence Act, is not required to be examined, but merely on the ground that the recovery was disbelieved. It cannot be said that the involvement of the appellant in the incident is doubtful, because as far as recovery part is concerned, accused appellants were challenged under section 412 IPC and under section 25 Arms Act. However, they were acquitted and the same has not been challenged. As far as argument of counsel for the appellant that it might be a case of poisoning, and after they became unconscious they were throttled or strangulated to death because bodies were found straight upward. Merely on this ground also, the prosecution story has not to be discarded. The doctor has not preserved viscera because he did not suspect as case of poisoning. According to the statement of Dr. R. N. Sharma, who conducted the post-mortem examination, the cause of death was injury on neck of Srimati Nilam and strangulation, and it was not a case of hanging, rather it was a case of strangulation. As far as the injury on the neck of deceased Anshul was concerned, he might have been killed by closing his mouth and pushing his neck, so it was a case of throttling. There was clean cut incised wound on neck. All the injuries were ante-mortem injuries, and the post-mortem report had sported the statement of PW5 Ujjwal. There is no contradiction to disbelieve his statement. Further, if statement of witnesses are trustworthy, then the same has not to be disbelieved, because the doctor did not preserve viscera and no opinion was obtained. The post-mortem report has not to be disbelieved in view of the statement of the witnesses, which is supported by the post-mortem report, and the same was proved by the doctor. As far as the accused appellants are concerned, they were neither named nor the recovery from them was proved beyond reasonable doubt. Hence, the same was disbelieved and they were acquitted under section 412 IPC. They were also not named by witness Ujjwal or any other witnesses. According to evidence against them, during investigation there was recovery, and first time they were identified before the court by the witness Ujjwal along with other accused. It is also clear from the record that the accused appellants appeared before the trial court on previous dates, and on subsequent date witness Ujjwal identified them. Hence, there was sufficient time and opportunity to identify them. No identification parade took place in the present case. The incident is of the year 2008, and after about 3 years, They were identified by child witness Ujjwal first time before the court. In this connection, it is also necessary to point out that character role entries are recorded in annual confidential remarks of an employee by superior officer on the basis of appraisal of his work and conduct during the course of a year, who has opportunity to look into the work and conduct of employee, and such annual confidential remarks are further required to be approved by next higher authority as indicated in various government orders relating to the government employees issued from time to time, whereas the punishments awarded to a government employee are always based on disciplinary action taken against such government employee, unless there is specific service rule regarding placement of the punishment in the service record, and the punishing authority in pursuance of such rules indicates that such punishment be placed in service record of employee, and further such punishment shall deprive the employee for a particular service benefits to be accrued during the course of employment of employee. In our considered opinion, in absence of such specific rule debarring an employee from any service benefits, such punishment cannot automatically deprive the service benefits to be accrued to the employee. Normally, under service rules applicable to the government employees of the state, the legal impact and implication of punishments awarded to them have been provided, such as dismissal and removal from service, debar the dismissed and removed employee from post retirement benefits and certain civil rights on such dismissal, whereas the punishment of removal would not deprive removed government servant from other civil rights except depriving him from post retirement dues and other service benefits. Likewise, reduction in rank does not deprive an employee from future promotion and other service benefits like post retirement dues. Similarly, stoppage of one increment for particular period deprives the employee from financial benefit of said increment, which is otherwise liable to be added in his pay scale on account of accrual of such increment. If two increments of an employee with cumulative effect have been stopped, such employee will not get the financial benefits of two increments which may be otherwise admissible to him in his pay scale. Thus, the legal impact and effect of stoppage of two annual increments with cumulative effect would be merely that the employee or officer would suffer loss in payment of his salary to the extent of denial of two increments which would be otherwise admissible to him, but for the said punishment he has been deprived of from said benefit of service. Thus, in the service jurisprudence, the employee who has been awarded punishment of stoppage of two increments would not lose the other benefits of service except the aforesaid financial loss in payment of salary. Therefore, in our considered opinion, the stoppage of two annual increments of the petitioner with cumulative effect cannot deprive him from other benefits of service, including his eligibility and entitlement for promotion to the next higher post if he is otherwise eligible and entitled for such promotion. Stop.